that once it is declared by the court do not have legislative power, there is not repeal. All these things are actually completely foreign to the structure and phraseology of Article 368. They don't fit in there. Either the Constitution stands amended or it does not stand amended. These are the two situations only. Once the declaration is of its void, then we should not learn to adopt the principle of East End dwelling. Should not allow the mind to boggle. Just because there is a gap not in the proceedings of the court and the declaration comes after a certain period of a certain lapse of time. This case, Minerva Mills case, 9 years time. So certain things happen. Court may say it. Court may say it will be retroactivity, but whatever has been done will not be disturbed. That the courts, we should shed the impression that the courts do not make law. The courts do make law. And the very doctrine of basic structure is something which has emerged from the pen of the court. So the courts are making law. Interregnum legislation, interstitial legislation, filling in the gap. There are so many forms in which the court today is, and very rightly, Mills.
Shortly put, it is called judge-made law.
Judge-made law. Now, we ought to bank upon Keshav Madhav Menon and all those earlier cases in the 50s, Peshi Kaka and so on, to hark back to those and bring them back on the table for discourse. Today, it's well accepted, well entrenched that the courts do make law. And so, therefore, the courts, if the court can say that our declaration will not operate backwards, it will save something, it will be treated as if in the past it was operating. Lordships can say that until this date it operates, but hereafter it will not, because we have declared it to be void. So all these things show that once the declaration is there, that declaration operates, in this case, being unrestricted, unqualified, it will go back to the root. It is as if it was never there. It is as if the Constitution never stood amended in terms of Section 4 of the 42nd Constitutional Amendment Bill. Even in that case, all these judgments which my learned friends have referred, even though they are of the 1950s, they have took caution to say that if the defect is of legislative incompetence, and I'll show that when I refer to those judgments, then they are void ab initio, of no effect. So this court has distinguished between a case of legislative incompetence and while an invalidity arising out of breach of either fundamental rights or some other constitutional provision.
Article 368 specifically refers to constituent power.
Yes.
I think that is why you are coining the phrase constitutional incompetence. Constituent incompetence. Now, legislative incompetence, you are differing. And is it because one is trying to make a change or variation in the Constitution, or is it because the other exercise is in respect of a legislation you are making the difference, or there is any other constitutional apart from the words used in Article 368?
Yes, grateful. The reason for my making this distinction is that in the case of a law being passed, as the procedure prescribed in 196 to 200, Article 196 to 200,
yes,
the law of fundamental rights, breaching the fundamental rights or some other constitutional limitation, like in Article 286.
Now, 13.2 says that any law which is in breach of Part 3 is void. So, how is that voidness distinguished from a law which is void on the ground that, or an act which is void on the ground that it is in breach of the basic structure?
So, on 13, there is some divergence in the judgments of this court. initially from case,
Constitutional amendment.
Only to allow.
Even
Struck down by the constitutional court. Any provision of the constitution or maybe some act also. That attains finality. Is there automatic change in the act also? Because this is never made. You have seen the Keshwananda also. We have seen your L. Chandra Kumar. There are a lot of, now you don't see those changes in the constitution. They are bound to do it or not? Or is it automatic?
Bible.
Not revival. Provision is struck down. Whether the constitution is deemed to be amended to
In
that,
my respectful submission, the statute stands corrected as it is, once your lordship declares.
it has to be.
There-
Shall be deemed to be
I'm not
deleted.
aware of a single act which this court has declared or any high court has declared ultra virus where the legislature has proceeded to pass an act to remove it from the state.
Yes, we have not seen that.
So subject to my lord, correction from my learned.
We have also not seen that. These are still there. in the
Never done, my
constitution.
lords. And I'm grateful for this question, Lord. The parliament has never passed, the legislatures, no state legislature has ever passed. They abide by the dictum of the court, and that's because of the mandate of the constitution flowing from Article 136, 141, 142, and more importantly, 144, which specifically says that all civil or authorities will have to
Abide by.
act in aid, very strong word, Lord, act in aid of the Supreme Court.
That doesn't create an anomalous situation. Somebody sees now.
So there's no anomaly at all, Lord. So Parliament never does it in India. We don't need to go abroad, across the 7 seas, Lord, and find out what America is doing or what UK is doing, what they feel like.
Parliament had not been doing, whether it should be done or not.
And they have also not created any, Lord, Taj Mahal, Lord, where all these dead acts, Lord, can be placed as a mausoleum, Lord. So it goes, it's gone.
No, only when an amending act, after the amendment is made and it comes to the statute, then the amending act is repealed.
Amending act.
Amending act is repealed. That is all become dead wood.
That is a kind of.
That exercise the legislature does.
Once they incorporate it,
Yes,
but that's a meaningless. But once the court declares word,
that's
I
a
have,
judicial verdict
not
unless
subject
they
to
remove the
correction.
basis of the judgment
your
and
lordship is right.
pass another validation.
No, but they do it. They do it. That's to remove the clutter.
Yes.
That is only removing the clutter, my lords. That is not a dead wood, since it has been incorporated,
Incorporated.
therefore. But the dead wood which is resulting from the declaration of the court, I have not come across, Lord, subject to correction, Lord, if there is. And that is of no effect. One more aspect,
It gets effaced from the constitution or from the
Yes.
statute.
it's not simply unenforceable. No. Sorry, Mr.
There is one more question on that. Now, it is at the option or free will of the publisher only what to publish in the book. Or some provision is struck down.
I'm sorry, Murali.
Any provision is struck down by the Supreme Court, finally,
Yes.
right? One is that 144 says everybody will come in aid. So whether in that context, the parliament or the state or the parliament, in constitution or the central statutes or the state statutes, don't follow that mandate by amending the act, because they are to come in aid, number one. Number two, it's the free will of the, you see this constitution, you must have a copy of it.
Yes, my friend.
Article 323A, 2D.
323B.
2D. Judicial review. and-
Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136.
This was struck down in L. Chandra Kumar.
Yes.
This book doesn't mention it.
So these are the publications.
This is what I'm asking. It is at the free will of the publisher only. No, how the layman will come to know? He will not search the law for
The
anything.
publisher should not include what is struck down.
Any note, anything, no, nothing is there. 323B,
The
3D also says.
The note is below, after the entire provision at page 313, if your lordship.
Like
That's correct.
book.
Layman, then we'll be out of business.
Mr. Shankarayan, but one thing to your credit, if you see a little bit of what's happening in this time of the year, I've noticed that your book of the Constitution, your means the one which is edited by you,
At the end
is
of the
bandied around quite a bit of late.
Yes.
So you might take credit for it.
at the end of the section.
Published by the Government of India in
So
2015.
these are executive exercise of publications.
This
but
is, the
they
question
should
is that
do.
only. If 144 is there, why don't they come in aid and give effect to the judgment?
Yes, they
It is
should.
giving effect to the
At
judgment.
least they should mention somewhere boldly that it
Why
doesn't
can't they-
survive.
Why can't they make the act only of constitution corrected as declared by this?
They should do it. All right.
Will it come in the legislation, directing a legislation?
In the universal publication word, in the footnote, they have mentioned,
Yes, in some books it is there, some books it is.
some it doesn't.
End
But
of the-
what they should be doing is that they should eliminate it from there.
Yes,
And in the footnote, they should provide that this was the provision which has been struck down.
it should be based on this.
So that one reads it.
This is the automatic act.
And in order to protect their skin, if they are to be questioned, that so-and-so council had suggested that this is how it should be done.
Kindly have this verse
At some point of time,
inoperative against non-citizens. Rights do not exist in vacuum, they must inhere in some person, natural or juridical, and under part 3, they inhere even in fluctuating bodies like religious denominations. See, the scheme underlying 13.1 and 13.2 is the same. Article 13.1 makes a pre-constitutional law to the extent of its inconsistency with fundamental rights. Article 13.2 makes a post-constitutional law void to the extent of its contravention of fundamental rights. In both cases, the law remains operative with non-citizens because Article 19 does not confer any fundamental rights on non-citizens. The voidness is not in them, but to the extent only of inconsistency or contravention. Therefore, void in Article 13.2 can only mean void as against persons whose fundamental rights are taken away or abridged by law. The law might be stillborn so far as the person, entities, or denominations, those fundamental rights are taken away or abridged, but there is no reason why this law should be void or stillborn as against those who have no such rights. So, even according to the learned author, in part it is stillborn, which is a theory which your lordship will have to test in some case. In this case, doesn't require your lordships to go into all this. But since my learned friends have raised it, therefore only I am trying to demonstrate that these dictums and the debate is in the context of breach of Article 19 and in the context of a debate of citizen versus non-citizen.
Yeah.
So in some appropriate case, your lordships may go into all this, but in the present case, it's a case of incompetence, constituent incompetence, which may be considered to be akin to legislative incompetence, where all these cases, including the learned author, are at one, that in this case of incompetence, it is null and void, ab initio, beginning, as if it was not there at all, as if it had no effect. And in case of 368, it will be a case where the Constitution does not stand amended on account of Section 4.
Article 368(4) also was struck down because judicial review of the 42nd Amendment also was barred.
That's right.
That was also struck down
That's-
in Minerva Mills.
Yes.
Section 55.
Then they brought in Lord separation of powers. And it is well settled, Lord. I will not trouble your lordships. In page 30 and 31, I have mentioned 3 cases. Your lordships have said that under the Constitution of India, there is no rigid separation of powers. Even this court makes rules, rules of court, rules regarding to servants, etc. So there are some legislative functions. Then there is, as I said, the court makes judicially also makes law. Not in the way the parliament does, but through interpretation and declarations. 141.
Most of the
So
rules,
overlapping of functions.
Yes,
civil servants make most of the rules.
that's right. Most of the rules are made by them. So there's no rigid separation. Even in the matter of judiciary, notwithstanding that the fact that it is a basic feature of the constitution, still the salaries are fixed by parliament. There's so many things which parliament does with regard to the courts and judiciary. The legislatures do.